Hello everyone, today is 23rd of July. My name is Sahil and welcome to the newspaper analysis. Guys, in today's video, we will be taking up the newspaper analysis of the entire Hindu newspaper and the good articles from the Indian Express Explained section also we will be taking up. Now guys, first of all, let's take the overview of the articles that we are taking up today. And guys, if you like our initiative, do press the like button and please do share the initiative. Now let's take the overview. Now guys, first of all, into the explained section, there is the laws for surveillance in India which are being used and the concerns. We will be taking up this particular article. Other article, guys, not very much important for the UPSC examination. Then guys, from the Mint, the attachments have been taken up with respect to the Tokyo Olympic that is going to start. Now guys, from the Hindu newspaper, this is the page number 1 taking up the overview. So guys, here we can see that the Tokyo Olympics, they are going to be started, and into that capacity the important facts for the prelims we will be taking up. Then guys, the parliament have been onto a disruption mode due to the Pegasus project. So that is the thing which is happening here. Guys, we can see that the raids etc have been mentioned, not very much important. Then guys, onto the city section also, the regional news etc has been there, not very much important for our examination. Then guys, further moving on, so into this particular capacity, the entire city section is not having very much important news. You can completely avoid it. Then guys, onto the editorial page, this particular editorial talks about the changes that are needed into the process in which the NEP is being implemented. We'll see what is there. Then guys, this article talks about the recent striking down of part 9b of the Indian Constitution. We'll see this. Then guys, this particular article talks about the Olympics. We will be covering it. Then guys, this article talks about the 100 years of CPC. One aspect is being talked about. Then guys, this article talks about the new draft e-rules. We'll see what has been there. Then guys, further moving on, this article talks about the stress and how we take the wrong decisions etc. Very much important substance is not there. Then guys, onto this particular page, we can see that the regional issues etc have been mentioned. But guys, here there's one particular article which talks about the marine pollution into the Ganga. So into that respect, we will see that what is important into this particular article. Then guys, here we can see that the High Court appointment of judges has been talked about. We'll see that what is the issue that is going on here. Then guys, the other aspects are not very much important. Then guys, further moving on, here we can see that the children who had become orphan due to the COVID and a kind of a government portal has also been established. We'll see what has happened here. Then guys, the celebrity moving to the High Court for the content removal. So what is right to forgotten, we'll be seeing here. Then guys, the other news are not very much important. Then guys, moving here onto the world page, we can see that the NSO is now being reviewed. So we'll see that what this particular issues. Then guys, onto the business page, now the Reserve Bank of India is planning its own digital currency. So what is this digital currency, how it will be helpful, all these issues will be seen. Then guys, other corporate news etc and the profits growth rates, not very much important for the corporate sector. Then guys, this is the sports page, fine, and that is all about today's newspaper overview. Now guys, let's take these articles one by one. Now friends, starting up with the today's GS quote. So today we will be taking a quote from the Theodore Roosevelt, who had talked about the credentials of great democracy. He says, a great democracy has got to be progressive or it will soon cease to be great or a democracy. No guys, a progressive democracy is characterized by an evolutionary process where onto the basis of dissent reforms are carried, onto the basis of welfareism the special rights are to be granted to the vulnerable sections, as well as the justice always needs to be the defining characteristic. So all these are the components of a progressive democracy and they are always needed to be the core defining features. And if they will not be there, neither the greatness will be there nor the democracy will be there. Guys, this particular idea we can utilize into the answers related to the GS paper number 2 as well as into the paper on essay. So that is all about today's GS quote, and now let's take the newspaper analysis one by one. Now friends, taking up the first article, so here we have clubbed the articles from the Mint newspaper as well as from the Hindu newspaper, and they are pertaining to the Olympics 2020 that are going to be started from today. Now guys, first of all, as we are into the 2021, but these Olympics are still called as Olympics 2020 because originally they were supposed to be held in 2020, but they have to be postponed due to the pandemic. Now guys, first of all, the host will be the Japan and the Olympics are being held and to the name of the Tokyo Olympics of 2020. Guys, last time the Japan hosted the Olympics was in 1964 and now this is the second time that the Japan is hosting the Olympics. Now guys, when we talk about this particular year's Olympics, now guys, first of all, the special thing is that India is sending the largest ever contingent into the Olympics, and India is sending a contingent of 228 members, where 127 athletes will be there. Moreover guys, when we talk about this particular Olympic, it is also special because the medals which have been crafted for this particular Olympics, they have been crafted by using the e-waste materials, so they can also be described as the green medals. Now guys, further moving, when we talk about the Olympic sports, they will be held into the different cities into the Japan. First of all, into the city of Tokyo and the Fukushima, these events will be conducted without the spectators, whereas some limited number of spectators will be allowed into the stadiums into the Miyagi as well as Shizuoka. Now guys, basically this is the first time that without the spectators such the big event is also holding up, but given the limitations of the pandemic, such kind of thing has to be carried. Then after that guys, we can see that the baseball and the softball, they are returning back into the Olympics after the 2008 Beijing Olympics. And guys, there will be also some of the new sports which have also been added. Here we can see that the karate, skateboarding, sport climbing and surfing has been added as the new sports into the Olympics. And guys, now there are the 41 sports that are being held into the Olympics, and this is the record number of sports that are being held. Then guys, in terms of the participants also, a kind of a more gender parity can be observed into this particular Olympics, because according to the International Olympic Committee, the women's participation into the Tokyo will be approximately 49%, which is more than 45% that was seen into the Rio. So basically even participation from both the men and the women is there. Now when we talk about this particular Olympic guys, we can see that the athletes are coming from more than 206 National Olympic Committee, and especially there is also a refugee Olympic team, and this refugee Olympic team will be participating and it will be representing the refugees around the world. Now this is the important thing guys. When we talk about the India's performance into the Olympics, India has won up till now 28 medals into the Olympics since it started the participation from 1900. And for the India, the best Olympic were the London Olympics of 2012, where India won the 6 Olympics. And guys, when we talk about the gold medal for the India, Abhinav Bindra is the only individual gold medalist from India. Fine. So guys, into this particular capacity, first of all, we see that only 28 medals are there, and India is promising to be a country having a demographic dividend. We are having a promising young population, but that young population is not translating into the national sportsmen, because the performance at the Olympics is not very much good. Guys, into this particular capacity, if I give you a reference, then guys, a few days back, we have taken one article where we have seen that now India needs to consider the idea of one state, one sport, where every state, onto the basis of the genetics that are found into that particular state, infrastructure that they are having, the preference of people, we need to identify a sport and we need to give the entire dedicated focus on to that. Now guys, we are having so many of the states, and if every state follows on one specific focus on one state into the sporting international sporting events, we can participate into a very good capacity. So these are the key takeaways into this particular article. Moreover guys, there are some other also small informations that you need to look. Guys, there is the Maria Tova. Now you can see this Maria Tova, it is the official mascot of this particular Olympics. So guys, that is all about this particular article. Now even there is one more aspect which is coming, that guys, even this particular Olympics, it is being criticized that it should not be held, because again we can see that into the Japan, the number of cases of the COVID, they are increasing, but guys, as very limited spectators are there, it can be held. And this is also one kind of opinion which is being generated. So that is all about all the issues guys. If you have an interest, you can follow the Olympics, particularly what have been the Indian achievements, you can follow it. So that is all. Now we'll move to the next article. Now guys, this particular article has been taken from the Indian Express newspaper, and it talks about the surveillance laws that are into the India and the concerns that they are having over the privacy. First of all guys, just the day before yesterday, we have taken up an excellent coverage onto the surveillance laws into the India, that is onto the 21st of the July. If you have not seen that particular attachment, you can see that also. Now coming to this particular article, Guys, see, you have seen that the Pegasus project has been carried by the journalism agencies across the world, and into this Pegasus project, it has been unveiled that into the India more than 300 individuals they have been spied, and it includes many of the people such as former judges, former election commissioner, many of the members of the opposition, businessmen, etc. Now, guys, first of all, the government says that they have not carried this kind of surveillance or snooping, and even it has also been said that if government wants that, it can legally carry the surveillance also under the specific legislative framework. So into this particular article, it has been seen that what are majorly those legislative frameworks in which if Indian government wants, it can carry the surveillance. Now, guys, first of all, it has been provided that there are the two legislations into this particular direction. The first one here is the Telegraph Act of 1885, and the second is the Information Technology Act of 2000. So under these legislations, we can carry the surveillance. Now, guys, first of all, if we talk about the Telegraph Act, within the Telegraph Act, there is a section number 5 under which the government can intercept the call in certain situations. These situations are when the interest of the country is there, the sovereignty related matters, integrity of India, security of the state, friendly relations with the foreign states, public order, or for preventing the incitement of an offense. So into all these particular matters, the interception of the telephone can be done by the government under the Telegraph Act section number 5. So this is the one legislation. Then, guys, the second legislation is the IT Act of 2000. Now under the IT Act of 2000, there is a section number 69, and under the section number 69, the interception or the surveillance can be carried by the government. Now, guys, here into this particular act, the grounds are comparatively more wider than the Telegraph Act. Now, guys, you can see that into the Telegraph Act, majorly big grounds are there. For example, for maintaining the relations with the foreign state, sovereignty, integrity. Guys, here there is one particular ground, that is for the investigation of an offense. Now, even I am carrying the investigation of an offense which pertains to the kidnapping of a person, I can say that, okay, in order to get more information into this, I need to tap the phone of Mr. XYZ. Now, how you will prove that that particular thing is linked here or not? It is a very vague ground. So, guys, under the IT Act, even very much vague grounds have been given. This particular aspect also comes. So, anyhow, the Telegraph Act and the IT Act, they provide the ground for the surveillance. But, guys, it has been observed by the Supreme Court in 1996, particularly for the Telegraph Act. Here, the Supreme Court into the Public Union for Civil Liberties versus Union of India case pointed out that there are the lack of procedural safeguards into the provision of the Telegraph Act. It was said that many a times the surveillance is being carried and they are not just maintaining that what are the logs, for what purpose the surveillance was carried, just onto a random and haywire basis they had carried the surveillance. So basically procedural safeguards are not there. So, guys, here into the PUCL case of 1996, the Supreme Court also provided that we need to constitute a kind of a committee which provides that what are the conditions under which the surveillance can be carried. And, guys, on to the basis of this guideline that was given by the Supreme Court, what happened in Telegraph Act, a kind of a check was introduced into the form of rule number 419A. Now, guys, the rule 419A, it provides that if a surveillance is to be carried, then the Secretary of the Government of India within the Ministry of Home Affairs can pass the order for the interception. And if, guys, at the state level the interception is to be carried, then the secretary level officer who is in charge of the Home Department can issue the directives for the state government. Is it clear? So, guys, some of the ground has been put there on by which only the surveillance can be carried. But, guys, even into these particular after this particular thing, we have seen that the surveillance norms have not been completely abided. This thing has been said by the Planning Commission report in 2012. So in 2012, Planning Commission and the group of expert on privacy issues, which was headed by the former Delhi High Court Chief Justice A.P. Shah, they said that there are significant gaps into the laws with respect to the surveillance and they have an implication onto the privacy. There are no specific norms. So these are the issues with respect to the surveillance laws in India. They have been there. Under that, government can carry the surveillance, but, guys, there are the inadequacies also there observed by the Planning Committee report as well as the Supreme Court judgment of 1996. But, guys, even up till now, significant or concrete steps have not been taken into this particular direction. Now guys, if I take the example of this Pegasus surveillance which happened, if government had to sanction this particular surveillance, government will be needing both of the acts together, the Telegraph Act, because guys at the end of the day your phone is being tapped, and the IT Act also, because guys at the end of the day your basically your all the internet interactions that you had through the different platforms, it is also being tracked. Now guys, into the surveillance capacity when we are talking, just yesterday we have taken up one article where we said that even many of the surveillance agencies, they are not coming under the legislative framework. They have not been most of the times created by an act. Into this capacity, there was a private members bill also that was introduced. Fine, that bill was introduced in 2013 as well as 2019, that all the surveillance agencies needs to bring under a kind of a legislation, but nothing has happened on to this aspect. Moreover guys, in our India there is not a kind of a parliamentary committee also which is asking the accountability of these surveillance authorities, whereas in other countries such mechanism is existing. So guys, this is all with respect to this surveillance related issues, laws, how they are getting a kind of a legitimacy. And one more implication is there, that they will also be having an implication onto the right to privacy, which has specifically been given by the Supreme Court into the Puttaswamy case. Fine. So that is all guys about this particular article. I hope you have understood it, and now we'll be moving to the next article. Now guys, this particular article talks about the recent judgment given by the Supreme Court, where the Supreme Court has struck the parts of the part 9b of the Indian Constitution. Now already we have taken up this particular article also the day it happened. Now guys, a little bit more nitty-gritties into this aspect we will be seeing here. Now first of all guys, when we talk about the part 9b of the Indian Constitution, it was inserted by the 97th Constitutional Amendment Act, which came in effect in 2012. Now guys, through this 97th Constitutional Amendment Act, part 9b which was added, it talked about the cooperative societies. Guys, when we talk about the cooperative societies, even into the directive principles of state policy, it has been provided that government need to come out with the framework so that the democratic and autonomous functioning of the cooperatives can take place. So in order to fulfill the directive principle of state policy only, government passed this 97th Constitutional Amendment Act, which inserted the part 9b for the cooperatives. Now guys, it has been provided that as this 97th Constitutional Amendment Act was inserted, at that point of time there were two mistakes that were committed. The mistake number one, it was provided here that guys, that when we talk about the cooperatives, it is a state subject under the schedule number 7. And being a state subject, only the state has the power to legislate into the matters of the cooperatives. But guys, what has happened into the 97th Constitutional Amendment Act, while laying down the framework for the cooperatives, even the center government provided the scope where the state government can be working, where the state government will be coming out with the norms for the cooperatives. So what happened? The center laid the ground where the state can work for the cooperatives. Now what has happened, the Supreme Court has said that why you told the state government that what is to be done, what is not to be done, how to be done, when the matter is only into the state list, how you have interfered into that particular matter. So this is one particular problem. Then the second problem here is this, that when this particular Constitutional Amendment Act was being passed in 2012, guys, it was a kind of a special type of Constitutional Amendment Act. So rather than just the special majority within the parliament, the 2/3 majority within the parliament, it was also needed that at least 50% of the states also need to ratify this particular amendment. But the ratification of the 50% of the states was not taken, and it was still passed. So on to these two particular grounds, this is a problem into the 97th Constitutional Amendment Act. What happened, guys, specifically the portions where the center directed the state government that okay, this is to be done, this is not to be done, those have been struck down. However, within the part number 9b, within the part number 9b, there were some of the portions which also pertained to the multi-state cooperatives. They have not been struck down. Why? Because it has been provided by the Supreme Court that okay, multi-state cooperatives is anyhow the subject of a union list only, and into that capacity if anything has been done, then it is not wrong, it could be carried. So the multi-state cooperatives aspect has not been struck. Fine. So guys, here we can see that the doctrine of severability has been adopted. Now doctrine of severability we have already discussed discussed that it simply means that whenever there is one particular legislation, and into that particular legislation, if two of the parts are problematic, only two parts can be removed. So that is a doctrine of severability. So here only specific parts have been removed. Now guys, after this particular all taking the information, there comes the analysis of this particular move. Now, number one, it was being seen onto the face that the part 9b which was added, it furthered the cooperative movement into the India, because many times we have seen that the cooperative movement has not been very much successful. There is the political interference, many times the elections did not happen, and this particular act tried to give a better framework. But guys, the second thing is also this, that India is operated onto the principles of quasi-federalism, and the quasi-federalism cannot be bypassed. So into this capacity only the Supreme Court has struck this particular portion. Now guys, there is one particular more issue that comes here. It comes that okay, when the matter of the cooperative is within the state list, then why first onto the first instance the center government interfered? So guys, here the center government is having a very simple kind of logic. The union government says that we did not interfere into the matter of the sub-state list, we did not change anything there, just we laid a kind of a guiding ground. So into this thing, why there is a need to take the permission from the state, why there is something wrong is happening? No, nothing wrong is there. But the Supreme Court had said that into this particular thing, the Supreme Court had said that ratification requirement will apply if there is any attempt to fetter the state legislature in any way while enacting a law in their own domain, even if there is no attempt to alter the distribution of legislative power between the union and state. It has been said that on ground, even if no change has been done, but even if you have directed the state government, then also you have conducted a kind of a wrong thing, and onto that particular ground this particular part has been struck down. Fine. So guys, that is a kind of a thing which has happened, and this moment needs to be more symbolic, because it here the center and union government needs to keep into the mind that the federal principles can never be overstepped, and in all the capacities they are needed to be kept into the mind. So that is all that key takeaway from this particular article. So guys, I hope that you have understood it, and now we'll be moving into the next article. Now guys, this particular article it talks about the new education policies, little bit of criticism. Now guys, it will be important for our GS paper number 2 under the topic of education. Now guys, first of all, what has been provided here, before going into that, we will be taking up some of the background. See, in 2020, government came out with the new education policy, and this new education policy was one of the biggest education reform in last 4 decades. Guys, the last education policy was enacted in 1986, which got amended in 1992, and after 1986 in 2020, the new education policy had came out. Now, the new education policy was very much comprehensive. It put the norms for the school education, for the higher level education. Now, guys, it has been provided that within the new education policy, it was provided that the education curriculum frameworks were also to be established. Guys, you know that now our focus has been shifted. We will be focusing on to the early childhood care. We will be focusing on to the teachers' education and all such kind of things. So for them, a kind of a curriculum was to be designed. Now guys, as the NEP is to be implemented, what is happening? As per the recommendations of NEP, the National Council of Education, Research and Training, that is the NCRT, it has tasked all the SCERT, that is the State Council of Educational Research and Training. So NCRT has given a task to the SCERT that they should develop the 4 state curriculum frameworks, and these 4 state curriculum frameworks, okay, every SCERT has to develop it. These will be for the school education, that how the school education is to be carried, you gave us a curriculum. How the early childhood care and education is to be carried, for that also the curriculum is to be done. How the teacher education is to be done, because into our country the pedagogical skills are not very much good. So for the teacher education a framework is to be developed, and for the adult education also a framework is to be developed. Now guys, as these frameworks will be developed by the SCRT to the NCRT, onto these particular frameworks, what will happen? The national curriculum framework will be designed. Now, all this particular process is happening. Now, guys, onto the ground, if we see, we find that, okay, NCRT is asking the framework from all the state CERTs from the states. So, a participative and a democratic process is going on. But guys, there is a little bit catch which is into this particular process. Now the NCRTs had also provided the SCRTs support, and the support has been provided in terms of guidance, training of personal, technology platform, etc. Moreover, guys, what has happened? The NCERT had provided the SCERT the kind of e-templates. Okay. Now, when this particular exercise will be carried to design the curriculum, obviously the SCERTs, they need to take the opinions of the different stakeholders. Now, when they will be taking up the opinions, it cannot be a random opinion. Okay, NCRT had given them the questionnaires that okay, you will be asking the 5 questions or 10 questions from all the stakeholders, and onto their response you will be making your curriculum frameworks. Now it has been said that as NCRT had provided these questionnaires or the MCQs, these questionnaires or MCQs might not give the entire representative picture what the stakeholders want, because guys, there might be a possibility that I might ask only those 5 questions from you onto which I want to emphasize. Okay, I might basically, if I'm just restricting your opinion, then guys, I might only get that kind of opinion which I already wanted. So it has been provided that this kind of questionnaire or the templates that one develops can emphasize certain kind of recommendations while muting some others. Okay, so NEP suppose give 10 recommendations, only 5 of the recommendations and I can highlight and ask into your questions whether and other 5 can I completely ignore. So guys, in full spirit, the NEP will not be implemented. So rather than asking the questions, specific MCQs, I ask them to give the holistic view from their own side in complete sense. Then secondly, guys, it has been provided that when this particular data will be cleaned, it will be organized, then the data may pick or only that particular thing which is already into the minds of the people that are handling the data. I can just pick up that particular thing which suits my own attitude, my own thinking, and I can leave all other things aside. So this particular thing will also not be good. So it has been provided that guys, whatever has been done by the NCRT, it needs to be more representative. The opinion of the different stakeholders need to be taken in such a way that all the diverse opinions are being reflected, and when dealing with the data which we have received, into that thing also our prejudices, our stereotypes need not to be there. Now guys, into this particular capacity, it has been provided that there is one particular inspiration that we can take, that is, we can take inspiration from the Secondary Education Commission report SCER, as well as from the Zakir Hussein's Basic National Education report. Now guys, it has been provided that these are very coherent and rigorous documents because they had placed the values and principles of democracy at the higher grounds. Now guys, into these particular reports, as the principles of participation, democracy, deliberation have been taken, such principles also needs to be the guiding force for the implementation of our new education policy 2020 also. So guys, it has been provided that now the time has come that it is again time to place the democratic ideal at the center of our education. So into this particular capacity, more representative democratic data collection process needs to be there, opinion collection process needs to be there. So guys, this is all the idea that has been provided into this particular article. Friends, I believe that you have understood it. Now guys, this particular article has been written in very technical kind of language. So if there might be a possibility that there are some jargons which you might not be able to understand, however, I believe that you should not sweat over it, because guys, generalistic opinions we need to have for the UPSC and not very much technical and very much specific, centering only on one aspect. We need to have a multidimensionality. So into this capacity, whatever has been taken, it is more than sufficient for our examination. So that is all, and now we'll be moving to the next article. Now guys, this particular article again taken up from the Hindu newspaper. Basically, it is talking about the new e-commerce rules that have been notified. Now guys, here basically kind of analysis on some 2-3 aspects have been done, but we will be taking up this particular article in a more comprehensive manner. First of all guys, what has happened? See, recently the Union Ministry of Consumer Affairs, Food and Public Distribution has proposed some of the changes to the e-commerce rules. Now these e-commerce rules have been notified under the Consumer Protection Act of 2019. Now, Consumer Protection Act 2019 says that the consumer needs to be safeguarded from the predatory pricing strategies. His interest is needed to be upheld, his right are needed to be safeguarded. Now, what is the opinion? Opinion is this, that now majority of the business is being done by the e-commerce websites such as the Amazon, Flipkart, etc. And now, as their cloud is increasing, there are some new practices which have come which might hamper the interest of the consumer. So therefore, these new e-commerce rules will be safeguarding the consumer. Now guys, it has been provided. Let's see first of all briefly the provisions which are there. Now first provision is there guys, that specific flash sales are to be banned. Now guys, the specific flash sales are those that, okay, on some of the events there will be the sale which will be giving hefty discounts on some of the items where you and everybody knows that, okay, discount is not possible. Now these flash sales, the specific flash sales are problematic because guys, here the people who are operating onto the brick and mortar model, they gets completely wiped out because they cannot afford such kind of flash sales. So these are to be banned, because it has been said that into such capacity, when the brick and mortar based models, they will be wiped out, at the end of the day consumer will be onto the whims and fancies of these particular websites. Then the next has been said that there needs to be the concept of fallback liability that is to be introduced. Now the concept of fallback liabilities, it means that guys, whoever the seller or the vendor who are operating onto a e-commerce, if the seller fails to deliver the goods, if he fails to deliver the services because of some negligence, then the e-commerce platform has to take the responsibility of such negligent behavior. So this is the fallback liability which is being talked about. Then the next provision that comes guys here is that a kind of a clear-cut definition also needs to be there for the unfair trade practices, and what could be the practical legal remedy to tackle such kind of things, it also needs to be there, because guys, now unfair trade practices are coming in many of the ways. One of the way is giving the deep discounts. Other way is that guys, because of their prominent clout, what they have done, they have gained in itself a kind of a dominance. Then the next thing that has come, that all these e-commerce websites, they need to appoint a chief compliance officer and a resident grievance officer, the resident who is a resident of India, so that if any complaint is there, these complaints can be resolved effectively. Then the next, it has been provided that guys, the delivery charges are also needed to be fixed, because many a times we have seen that particularly into the apps such as the Zomato, Swiggy, many a times the surge pricing etc are needed to be there. So these delivery charges are needed to be fixed. Then guys, next it has been provided that all major e-marketplace entities should establish their data centers into the India. Now this is going into the direction of the data localization. Then it has been provided that these e-commerce companies need not to manipulate the search results. Many a time it has been seen that these e-commerce companies, they are showing only those products which they want. So some prominent products or some seller prominently are shown. So these kind of things need not to be there. Then guys, next it has been provided that the e-commerce companies, they need to restrict from making available any personal information to any third party. So a large number of your information is being collected that should not be shared. Then the next, it has been said that the companies, they need to promote the domestic alternatives rather than the imported goods. And then the next, it has been provided that they also need to mandatorily become the part of the national consumer helpline. So guys, these are the specific norms which have been initiated, or the draft which have been provided, which will be applicable onto the e-commerce companies. Now guys, it will not be including only the merchandise e-commerce companies, but guys, many of the service delivery companies where the food is being delivered, it will also be covered. So guys, the food delivery app, hotel booking website, merchandise goods websites such as Flipkart, Amazon, all they will be covered under this. So these are number one, the provisions with respect to the new rules. Now taking up the critical assessment. Number one guys, the problem is of implementation. Now see, many a times we see that the rules and policies are not a problem, but their implementation is a problem. Guys, even there have been the norms that if you want, then there is a do not disturb list in terms of our telecom, our mobile phone. And if we enter into that do not list, we cannot receive any kind of promotional messages. But guys, still they are being received. So how they will be implemented, it is a problem. Then second problem guys, that has been said that you are taking them, okay, national consumer helpline is to be joined, then you are saying that there needs to be a chief compliance officer, resident grievance officer. But guys, already there are the customer cares which have been established by these companies, where you can raise your complaints and that get resolved also. So why the need of again this thing? Secondly, it has also been provided that guys, the intense competition is also there into the market. So in order to stay ahead of the competition, they themselves are focusing on to the customer care. Then the next third thing which has been provided, that this kind of a domestic goods aspect, it is a kind of a problematic thing. You have said that domestic goods are to be promoted. Now even if the domestic goods are inferior, then also are they to be promoted. And guys, rather than protectionism, we need to work that how our goods can be better into the quality, so that automatically consumer chooses them. Now, it can be well understood that we are taking up the Atmanirbhar Bharat Abhiyan, and under the Atmanirbhar Bharat Abhiyan, the promotion of the domestic goods is there. But guys, rather than showing just a good prominently, we need to focus more on to the qualitative aspect. Then the next has been the issue of the flash sales. Now it has been said that the flash sales are being banned for the consumer interest. But guys, how they impact the consumer? Even into the flash sale, the consumer are getting the deep discounts and they are getting the affordable products. Now, though there is one more aspect that comes, that it has been seen that into the USA, many a times the dominant players such as Walmart, they had wiped the local vendors. So into that capacity, it will be safeguarding them. Okay, so onto that ground, the flash sale ground is a kind of a mixed provision, which has a criticism also as well as the appreciation also. Then guys, the next aspect that comes here is the norms that have been announced by the Ministry of Consumer Affairs. They are very much overarching and they are overlapping with the ambit of many of the other organizations. For example, guys, the regulations of the firms have been done in order to promote better competition. But guys, there is already the Competition Commission of India. So to look forward that okay, the better competition is there, CCI should have intervened. Then the next thing is that guys, that they are talking about the data privacy, but the data privacy is needed to be addressed by the data protection law. Why they are interfering? Again, this is a kind of an overlapping aspect that has come. So guys, because of this particular thing also, the criticisms have been made. Now you might agree with these criticisms, you might not agree with it, but for the sake of our UPSC examination, you need to have such kind of provisions as well as their critical assessment into your mind. So that is all about this particular article, guys. I hope you have understood. Now we'll move to the next article. Now guys, this particular article talks about that see, now 100 years of the Communist Party of China has been completed, and on to the 100 years we see that okay, what China has achieved, what China has not achieved. Into this capacity, guys, everybody is talking about the spectacular rise of the China. Fine, the technological rise, the rise in terms of their economic prowess and etc. But guys, this article is talking that still the status of a Chinese worker is not very much good. Okay, onto that ground also the China's success is there. Now guys, much of the aspects of this particular article pertains to the internal issues with respect to the China, which are not very much important for the UPSC. So guys, for that particular thing, you might skip this particular article. However, if you have a specific interest, you can go read it also, but much of the substance is not there. Now we'll move to the next article. Now guys, this particular article pertains to the Reserve Bank of India's plan to start the digital currency pilots. Now guys, the digital currency pilots, it means that on a trial basis, on a trial version, digital currencies feasibility into the India will be checked, and it will be important for our GS paper number 3 into the issues related to the Indian economy. Now, many a times it has been seen that India has a target to become a kind of a digital economy. Now, into this respect, guys, what has happened? Few days back, a high-level inter-ministerial committee which was set up by the finance ministry had recommended that now we should introduce a central bank digital currency, that is the CBDC. Now, into this capacity, some of the changes into the legal framework into the RBI Act of 1934 etc. has to be made. Now guys, when we talk about the present mandate of the Reserve Bank of India, it has been given a mandate under the RBI Act that they can issue the bank notes which will be the legal tender, and these legal tender are to be accepted for the day-to-day transaction. Now guys, by amending the RBI Act, we will be enabling the ground for the CBDC, that is the digital currencies, Now guys, these digital currencies can be used for settling the transaction. Now if I want to give you I want to carry a transaction with you, what needs to happen? A kind of an interbank transfer needs to happen, and into this interbank transfer many a times the service costs are imposed by the banks. Sometimes guys there might not be the digital connectivity, and into that this interbank transfer process might not be completed. Now guys, what is happening? A kind of a digital currency is coming here. No interbank transfers will be there. It is just I had sent you a message into this particular way, I can transfer this digital currency onto you, and it will be under the purview of the Reserve Bank of India. Now guys, it has been provided that such official digital currency will be helpful in many of the aspects. For example, it will reduce the cost of currency management, as well as the real-time payment will happen without any interbank settlement. Guys, the connectivity issues, etc., that particular problem can also be resolved. Then secondly guys, it has also been provided that when we see the India, though into the digitization adoption after the UPI particularly we have done very much good, but guys still India's high currency to GDP ratio is very much problematic, and as high currency to GDP ratio is there, again the CBDC, that is the digital currency, will be helping India in to the large extent. Then further guys, it has been provided that the foreign trade transactions could also be speeded up between the different countries if this digital currency, central bank digital currency, we adopt. If I have exported some of the good to another country, and from there a person wants to send me the money, so why this digital currency? He can directly send me the money. Interbank transfers, many of the formalities will be resolved. So into this particular capacity guys, now the RBI is planning for the digital currency. Now guys, I have not talked specific technical aspects here because they have not been finalized up till now. Guys, it is just a kind of a pilot onto which the government is thinking. So what form will be there, what technology there will be there, what process of transfer will be there, it has not been finalized, and as and when it will be coming, we will see it. It is just an idea which you can also utilize in your answers. So that is all about this particular article, and now we'll be moving to the next article. Now guys, this particular article talks about the marine pollution, and therefore under the GS paper number 3, the topics related to the ecology, it will be an important thing. Now it has been provided that guys, recently a study has been carried, and the study is the quantitative analysis of microplastics along the river Ganga. And into this particular study, it has been found that substantially high microplastics are flowing within the Ganga river, particularly after the Haridwar. Now, first of all, when we talk about the microplastics, they are the synthetic solid particles which range from 1 micrometer to 5 millimeter, and they are insoluble in water. And because they are insoluble in water, they will be persistently maintained. They will be taken up by the marine life. If you eat the fishes, etc., it will come into your system also, and they are being passed here within the marine ecology. Then guys, when we talk about the microplastics, they have been now called as the major source of marine pollution. Now guys, when we talk about the big chunks of plastic, they can be taken out, they can be filtered, but they are now becoming a very big problem, and they are unregulated. In that, the end of the day, they are ending into the seas. So into this capacity guys, huge level of microplastics have been found. This is one aspect. Now guys, if we go a little bit beyond the scope of this particular article, see, already government is running the Namami Ganga project, or the National Mission for the Clean Ganga. Under the Namami Ganga project, more than 20,000 crore rupees have been taken up. But guys, still the microplastics are a very big problem into the Ganga river. Guys, when we talk about the Namami Ganga project, it is being operated under the Ministry of Jal Shakti and was started in 2014. Now guys, the program is implemented by the National Mission for Clean Ganga, as well as into the state, it is operated by the state program management groups. Now when we talk about the National Mission for Clean Ganga, it is the implementation wing of the National Ganga Council. Fine. So first of all, there is a National Ganga Council. Then under the National Ganga Council, there is a National Mission for Clean Ganga coordinating wing, which coordinates or implements the actions onto the ground. Then when we talk about this particular national mission on the Namami Ganga project, sorry, it has the four main pillars, that is the sewerage treatment infrastructure and industrial effluent monitoring, so that the solid waste or the chemical waste is not being dumped into the river. Then guys, the riverfront development and river surface cleaning will be carried. Then the biodiversity and afforestation around the river will be ensured, and finally the public awareness will also be made. So guys, even after having the ambitious project of the Namami Gange, the actions have not been beared the grounds. Now guys, even into the GS paper number 2, the evaluation of the government's developmental scheme also we can put it. So that is all about this particular article, and now we'll be moving to the next article. Now guys, this particular article pertains to the GS paper number 2, judicial appointments. Now first of all guys, when we talk about the judiciary, see, many times the present Chief Justice of India, N.V. Raman, he had said that there are judicial backlogs into our judicial system. More than 3.3 crore cases are there into the backlog. Now first problem, many of the problems, there is a biggest problem also, that is guys, our high courts, they are not operating at the sanctioned capacity, and even to the lower judiciary also the same kind of problem is there. When we talk about the high courts guys, the sanction strength of our high court is 1098, but the working strength right now is just 645. So immediately the vacancies are needed to be fulfilled. Now guys, into this capacity, it has been provided by the executive that out of the 80 names that have been recommended by the collegiums into the 1 year, 45 have been appointed and rest are being appointed. So guys, here a justification has been given that filling the vacancies at the level of judiciary is a continuous, integrated and collaborative process between the executive and the judiciary, where all the stakeholders deliberation consultation is required, and into this particular direction it takes a particular level of time. Fine. So this particular small kind of attachment is there. Fine. I hope you have understood it. But guys, even though time is to be taken, the process of appointment needs to be fair. It needs to be comprehensive, but at the same time guys, it also needs to be such efficiently be done that such low working strengths are not there, so that cases in a fast manner could be disposed of. So that is all about this article. Now we'll be moving to the next article. Now guys, this particular article talks about the efforts taken by the different state government for the orphans. Now already guys, yesterday we have taken up comprehensively the impact of the pandemic onto the children, which will be important under the GS paper number 2, vulnerable sections of society. We have also seen that guys, when the children are becoming orphaned due to the COVID, the central government, it came out with a comprehensive fiscal aid package where a corpus of 10 lakh rupees were to be given to the children. Their studies into the Sainik school, into the Kendriya Vidyalaya or even the private school will be provided. The health benefits under the Ayushman Bharat Abhiyan, they will be provided. Now guys, seeing this comprehensive fiscal aid package by the center, various state governments has also came out and they had rolled out the different schemes for the protection of the orphan children into their state. So guys, here what has happened, the example of the different governments have been done. The example of the government of Delhi, Tamil Nadu, Kerala, Karnataka have been taken. You don't need to go into this particular thing that okay, what every state government has done, because that such kind of thing is not very much important for the UPSC. However, just you can say that onto the line of this, into the state government also the initiatives have been taken up. Fine. For example guys, if you see the steps that have been taken up by the Delhi government, then guys, the Delhi government has provided that under the Mukhyamantri COVID-19 Parivar Arthik Sahayata Yojana, 50,000 rupees would be given as a one-time compensation, and apart from this 50,000 rupees, additional 2,500 rupees every month will be given to the children till they turn the age of 25 years. So these are some of the steps that have been done. Moreover guys, now apart from this, one more development is there, that a government portal have been established for the children who have been orphaned by the COVID-19. Now this particular portal is the www.pmcaresforchildren.in. Now onto this particular portal, anybody can report for the children who had become orphaned due to the COVID-19, and the government through the different schemes will try to reach with those children and will provide them support and assistance. So that is all about this particular article guys. Fine. And guys, if you had not seen the yesterday's newspaper analysis, please do look into it. You will find that exact timing into the timestamp, and please do look for the impact of the pandemic onto the children. You can directly put it into your answers. So that is all about this, and now we'll be moving to the next article. Now guys, this particular article could be used as a kind of a reference in our GS paper number 2 related answers. Now see guys, what has happened here. Into this particular article, there is one of a celebrity, fine, into way back in 2008, 2000, way back in 2009, 10, 2013, he committed some wrong things, and those things have been captured onto the videos, onto the pictures. Now guys, the person has basically even he had underwent the punishment for the wrongdoings that he had done, but still those pictures are circulated online, and still he is facing a kind of an assassination of the character. Now the celebrity has reached to the Delhi High Court and had said that the right to forgotten is to be given. Fine, it has been said that this basically there is an implication on his right to privacy, as the information is still onto the internet, and guys, it is having a kind of a detrimental effect onto his life, and guys, even his article number 21 is getting impacted. It has been provided here that there is the French jurisprudence which provides the right to oblivion. Fine, right to oblivion, right to forget is being provided. Now guys, the right to forget needs to be provided to this particular person also. Those videos, those pictures needed to be deleted from the internet, and it has been provided that the B.N. Shri Krishna committee, which drafted the personal data protection bill in 2018, also provided for the right to be forgotten. So this right to be forgotten needs to be given to him. All the data's pictures needed to be deleted. So guys, into this particular capacity, the Delhi High Court has also issued notice onto the center that how these videos and pictures could be removed. So guys, this is the new evolving dimensions of the fundamental rights, that now not only the privacy but the right to be forgotten also is being demanded, and even the judiciary is accepting it, and even the B.N. Shri Krishna committee also accepted it. So please do utilize it into your understanding. So that is all about this article. Now we'll be moving to the next article. Now guys, this article pertains to the Pegasus project. So as the Pegasus project had happened, and as it has been seen that many of the activists, journalists, they have been spied upon using the Pegasus spyware. Now the NSO firm who actually makes this particular spyware, it is being questioned by the Israel. Fine, it has been said that okay, how this particular spyware is being used for surveillance onto the activists, onto the opposition members, onto the members of judiciary, etc. Into this capacity, the NSO had said that we have given the spyware only to the governments which have been vetted out, and the NSO says that we are not guilty into any of the process. Our intentions were good. Now guys, this investigation is going on, and we'll see that okay, what will be the findings. However, into the line to line details you need not to go, because not important for our examination. So guys, that is all about this particular article. With this guys, this is all about the today's newspaper analysis. Friends, I believe that you are understanding this initiative and it is turning to be fruitful for you. So that is all for today. Thank you so much.